I warmly welcome you to this explanatory video, which will explain you the cycle of European policymaking. The main actors are mostly well known, but how do they interact with each other? Who is preparing new law? Who is deciding on it? And how are non-governmental actors from the civil society involved? Who is in charge for implementing new law? And how is compliance guaranteed? It is the European Commission who has the monopoly to initiate a legislative proposal. Their directorate generals are in charge for drafting new law, which will be checked by the legal service for their legality with the treaties before they are passed on for decision-making in the European Parliament and the Council of the European Union. The 705 members of the European Parliament will be the first to decide on the legislative proposal. They see themselves primarily as representatives of all 453 million citizens of the European Union. The members of European Parliament come together to form party groups in the European Parliament in order to coordinate their positions with one another. The final decision is made by the Council of the European Union, also known as the Council of Ministers. In the Council, the interests of the member states are represented by the respective representatives of the ministries concerned. They debate and decide on the Commission's legislative proposal and already include the decisions made in the European Parliament. Austria is represented in the Council by its permanent representatives at COREPER, and also through national experts in the approximately 150 Council working groups. The permanent representation is based in Brussels, and its employees meet weekly with their colleagues from the other member states. In the following, we consider the respective stages of EU policymaking under the ordinary legislative procedure. Stage 1 concerns the analysis and development of new policies in the context of policy research and the so-called agenda setting. The topics are determined which are to be dealt with in more detail and promptly. The European Commission is responsible for this process. They have the monopoly to start legislative initiatives. Around 20,000 officials work in the 23 general directorates on the respective policy areas and develop rules and measures to control them. They will be supported in their work by the 850 expert committees and 40 specialist agencies. It starts with the problem identification and interpretation. For this purpose, the officials of the European Commission stay in close and regular contact with distinct actors to address the most relevant topics and to elaborate on possible solutions on respective policy problems. The core actors in this process are the 23 Directorate Generals of the European Commission. In 50% of the cases, however, the Director Generals are commissioned from outside to draw up legislative proposals. For example, the European Parliament or the Council of the European Union with a simple majority, or by the European Court of Justice, as well as through a citizens' initiative. Citizens' initiatives that have received over 1 million signatures from a quarter of the member states will be discussed by the European Parliament and the Council of the European Union. In the best case scenario, this citizens' initiative will initiate a debate that will lead to a concrete bill in the medium term. Current examples are the No Profit on Pandemic initiative, which, among other things, advocates the release of patents on COVID-19 vaccines. Other examples are the initiative for a bee-friendly agriculture and the initiative for a Europe-wide unconditional basic income. Furthermore, a quarter of the member states can advise the Commission to prepare a legislative proposal in the field of judicial cooperation in criminal matters and police cooperation. This stage is followed by policy research. In order to deal with a topic in more detail, this will be discussed with various experts and interest groups. The more than 850 expert committees in the Commission serve this purpose. In addition, the 40 specialist agencies support the Commission with expertise. Many legislative proposals have been planned and discussed for a long time. So-called green papers and white papers are often used to kick off a debate. Green papers are intended to provide food for thought on specific topics at European level. They are mainly aimed at interested parties who are thus invited to participate in the process of consultation and debate based on these proposals made in the green paper. In some cases, they initiate legislative proposals which then will be explained in white papers. As an example, consider the green paper on a strategy for securing energy supply, as seen on the screen, or the green paper on artificial intelligence. Examples of white papers are, for example, the white paper on handling and regulating artificial intelligence, and the white paper on building a defense union. They serve as a basis for discussion when drafting possible legislative proposals. Civil society actors and interest groups use these white papers as an opportunity to express their views and make contributions at an early stage. Here on the screen, you see an example of real-world opinions from civil society organizations and other interest groups on the artificial intelligence white paper. At the beginning of each legislative period, the Commissioner President publishes its 5 years working program, which includes prioritized and planned legislation in the upcoming legislative period. The nominated Commissioner President presents this to the European Parliament, who has to give its consent on its election and therefore also on its 5-year working program. From this rough planning, concrete legislative proposals are then divided into annual programs and then processed accordingly. Thus, all actors who are involved or have certain interests in respective policy areas are informed well ahead. Many committees have already worked on a bill before it will be decided. The aim is to work out a bill that will reach consent by a majority in the European Parliament and the Council of Ministers. That is why many different actors are invited to working meetings in the relevant departments of the Director Generals in charge. In the context of formal consultation procedures, representatives of civil society and interest groups can also comment on possible consents and/or give suggestions. As a rule, these public consultations last around 3 months. There is also a lively exchange with lobbyists who provide the Commission with expertise and information. The Commission pays attention to the highest possible transparency, and therefore, since 2014, all meetings between higher ranked officials of the Commission and lobbyists have been made public at least 2 weeks before the meeting. Also, only lobbyists who are recorded in the so-called transparency register may be received. The European Parliament adopted this practice in 2016. The results of all these debates, discussions, working groups will ultimately flow into the final legislative proposal. Before a bill is submitted for decision, the planned bill has gone through a so-called impact assessment, where this bill will get evaluated with regard to its consequences and effects, as well as the resources who are required for its implementation. The European Commission also determines whether the law should be a regulation or a directive. A regulation means that the law is directly binding will be decided on the EU level, and it has a direct impact on European Union legislation. A directive has to be implemented by national parliaments first into national legislation. So they have the choice of the form and the means to achieve an agreed legal goal in their hand. Subsequently, in stage 2, the decision making. It's about the decision making of legislative proposals, which will be decided through the European Parliament and the Council of Ministers. In addition, the bill will be sent to the European Economic and Social Committee, which represents key representatives of civil society and the social partners. Further, the Committee of the Regions, which submits the interests of local authorities such as municipalities and federal states. They can give their opinion within 8 weeks, and also within 8 weeks, the national parliaments are asked to check the legislative proposal in whether it is compliant to the principle of subsidiarity, or they are of the opinion that this principle of subsidiarity is violated by this legislative proposal. If a third of the national parliaments are of the opinion that there is a violation of subsidiarity, the yellow card is triggered, which prompts the Commission to re-examine the proposal or to justify it. However, if more than 50% of the national parliaments join the complaint, the orange card will be drawn. This provides for a vote in the Council and the European Parliament on the admissibility of the bill. They both have to vote in favor. They have to recognize actually the admissibility with a qualified majority. The legislative procedure allows up to 3 readings. One reading always refers to the exchange between the Commission, European Parliament, and the Council of the European Union. Incidentally, there is no time limit during the first reading. At the beginning of each reading, there's a meeting of the respective key actors of the main 3 institutions, the Commission, the European Parliament, and the Council of the European Union. These meetings are called trilogue meetings. These meetings are taking place in an informal setting. The respective actors who are included and participate in these trilogue meetings are first of all the head of the responsible Director General in the Commission as representative of the administrative level, as well as the representative of the cabinet of the Commissioner, who is responsible for the political coordination in the Commission. Both of them represent the Commission in trilogue meetings. The European Parliament is represented by the respective rapporteur, or as well by the chairperson of the respective parliamentary committee. The Council of Ministers in turn is represented by the current presidency, actually. It's the country who is holding the presidency and thus chairing the council during that time. The respective ministry of the country who is holding the presidency is in turn represented by its permanent representatives in Brussels. The decision is then made twice in the so-called decision making. First of all, the European Parliament with its 705 MEPs decide, and then the representatives of the member states who meet in the Council of the European Union, they also vote on this legislative proposal. First of all, the European Parliament votes with a simple majority. It can accept the legislative proposal without any reservation or subject to changes added to the documents, so-called amendments. The second step is to vote in the Council of Ministers, which can unreservedly approve the original legislative proposal or as well the amendment by the European Parliament with a double majority. A double majority means the approval of 55% of the member countries who also represent at least 65% of the population. In the event of a rejection or a dissenting Council position, the legislative proposal will be dealt with again and the so-called second reading will take place. However, the second reading is limited to 12 weeks. During this time, the European Parliament and the Council of Ministers have to decide on the bill. The European Parliament again has three options. Either it accepts the Council position or it rejects it. Then the legislative process has failed completely, or it proposes a new amendment. Then it comes to the third reading. This differs from the second reading in that there is initially mediating a conciliation process in the trilogue format, where the respective representatives of the three institutions jointly discuss whether and how an agreement still can be reached. After they have agreed on a text, the institutions, each of them has to vote on this proposal separately, but no further changes are allowed to the document. This process, the third reading, actually is differentiated between 6 weeks of conciliation within the trilogue format and 6 weeks where the voting has to take place. However, the analysis of the past legislative periods have shown that a large part of the bills are already passed within the first reading. Specifically, this is the case in almost 90% of the proceedings. Finally, the European Commission is entrusted with the implementation of the law. Depending on the act of law, either a regulation or a directive. In this case, the implementation lies either with the Commission or the national parliaments in the case of a directive. In both cases, so-called comitology committees can be set up. They support the Commission in the implementation of a regulation or the national parliament in the implementation of a directive. These comitology committees are formed on the proposal of the Council of Ministers and are composed of voting representatives from the national ministries. These comitology committees enable a dialogue between national authorities and are intended to ensure that the arrangements made correspond to the circumstances in the respective countries, and all member states in this regard, if it's a directive, are able to implement a harmonized bill, actually. In stage 3, the law that has already been adopted is now implemented and enforced. As soon as a law has been passed, they apply without restriction to the respective area after a legally agreed period. From now on, the European Commission is responsible for the administration of law enforcement. And in the event of non-compliance or lack of compliance in either direction, it can initiate, and it has to initiate, an infringement procedure at the European Court of Justice based in Luxembourg. As of March 2021, 1,849 proceedings are pending. 77 out of these relate to Austria. The majority, however, are concerning late implementations of EU directives. The final stage 4 closes the circle and includes the evaluation of a policy area and its existing rules with regard to the degree of the target achievement and efficiency. It is in the task of the European Commission, in close contact and exchange with the member states and the members of the European Parliament, as well as relevant stakeholders from the civil society, to identify any deficiencies in the achievement of goals and, based on this, to develop a new proposed solution in order to best address the policy areas assigned to its shape. If deficiencies are found here, which the Director General in the European Commission considers crucial, the process begins again with a new proposal to remedy the deficiencies in the policy-making process. Thank you for your interest in European policymaking, and I hope that this explanatory video has helped to give you a good insight into what is going on in EU policymaking. This explanatory video is made available to you by the University of Applied Sciences of the BFE Vienna and was made possible with the kind support of the Magistrat 23 of the city of Vienna. Bernhard Zahlinger is responsible for this video, who works as a lecturer and research assistant in the course European Economics and Business Management, as well as at the Institute for Political Science at the University of Vienna.